to Write a Tax-Efficient Will, read by the author Deborah Bowers, Chapter 1. Why write a will? In this chapter, we shall discuss what a will is, whether you should consider writing one, and how writing one may help you save inheritance tax. We shall also look at what criteria needs to be satisfied to ensure that your will is valid. This is not a book intended to instruct you on the laws of wills, but rather one aiming to bridge the gap in the minds of most people between will writing and inheritance tax. Discussions on the law about wills will be brief, restricted to necessary guidance to assist the reader's understanding of common terms used in will writing. A will is a declaration of how you would like your assets to be managed or distributed on your death. If you have not made a will at the time of your death, your assets may be divided in accordance with the laws of intestacy, which apply in the jurisdiction where you are domiciled. For example, if you have lived in England and Wales all your life, then your property will be distributed as per the laws governing the distribution of assets when a person dies without a will in England and Wales. This is commonly referred to as intestacy. For those who live in Scotland or are domiciled there, their assets will be determined following the laws of intestacy in Scotland. In Appendix 4, I have provided a chart showing how the law of England and Wales distributes assets of persons who have died without a will in England and Wales. In Appendix 5, there is a chart showing how the laws of Scotland distributes the assets of persons who die without a will in Scotland. There are a few critical things that one needs when deciding to write a will. The first point we will discuss here is one's financial position. It is a good idea to have an appreciation of your net worth. Many people believe that they have nothing, are worth nothing, and do not need a will. You may be surprised to realize that you are worth much more than you imagined. Alternatively, you may be surprised to realize that you are worth much less. The beauty of writing a will lies in the fact that you could be making provision for property that you may have received unexpectedly. In order to get an idea of what you are worth, you can complete the simple assets and liabilities sheet, which can be found at the back of this book in Appendix 1. The second thing to remember is that the rules surrounding the validity of a will in England and Wales. English law does not require special qualifications to enable someone to write a will. Anyone can write a will. The law, however, places great emphasis on whether or not a will is valid. So, if you are concerned about writing a will which does not render itself open to flimsy challenges, you should be certain to follow the formalities required to ensure the validity of your will. The important things to remember when writing a will are that 1. You should make or write a will of your own volition. It should be your decision to write your will. You should be sane when you write your will. You should not be suffering from any mental delusions. 3. You understand exactly what you are doing and the consequences of the distributions you are making in your will. 4. You should comply with the right formalities for signing a will in your jurisdiction, thereby ensuring its validity when you are no longer with us. 5. You should intend, by complying with the formalities for making a will, to give effect to your will. In England and Wales, you need to ensure that when you sign your will, you do so in the presence of two persons present at the same time who see you sign the will and who sign as your witnesses in your presence during the same sitting. So all three of you must be present together and see what the other is doing, knowing that you are doing so to give effect to your will. This does not mean that the witness should know the contents of your will. Further, you should ensure that none of your witnesses are beneficiaries or stand to gain anything from your will. In other words, the persons who witness you signing your will should not be given a benefit or any gifts in your will. Ensure that the witnesses have nothing to gain from your will. There could be variations or exceptions to how a will may be deemed valid, given various signing scenarios, but I would advise that you stick to the description given above to ensure validity in accordance with the laws of England and Wales. The witnesses should also not be the husband, the wife, or the civil partner of any person who you have gifted property in the will. If this is the case, the will may remain valid, but the gift to the witness's husband or wife or partner could fail. Use witnesses who are unlikely to benefit directly or indirectly from your will. It is also important that your witnesses fully appreciate what they are participating in. Sighted witnesses are recommended, and persons who could write and read and who are not suffering from any mental disorders. It is imperative that your witnesses should be reliable and able to substantiate by giving evidence in court as to how your will was attested, should the need arise. Thirdly, as far as English law is concerned, your property is yours and you may do with it what you will, subject to a few adjustments a court could make based on a case-by-case basis, such as making provisions for dependents. However, before delving into our various examples of wills based on the life of Jane, let us do some preparatory work, defining some commonly used terms in will writing, some inheritance tax essentials, and the groundwork which may assist you before you embark upon writing your will. It is good to understand the roles all people mentioned in your will play. In Appendix 1, I have provided a checklist to be completed setting out your assets. This will help you arrive at your net worth. In Appendix 2, I have provided a form to guide you on what you should consider before giving instructions to the drafter. By completing these two forms, you will be ready with the information needed to get your will off to a great start. This is the end of Chapter 1, Why Write a Will?